with technical difficulties and all, John has hooked us up to some other program that we've never used before. And you know how I am with tech, so I'm sure we're not going to have any problems at all. I am going to do my best to follow the chat. We're still going to go through all of the issues that popped up today in jury selection the charge conference dealing with the jury instructions. We're going to talk about some of the arguments the lawyers made, some of the arguments they've abandoned, but not necessarily the arguments as much as the instructions coming from the judge, which there's a very big difference. We'll talk about that and how I think they're going to use and craft these arguments. That'll be very different. And then we will also talk about the argument Alessi made for a better instruction, a curative instruction dealing with what Hank Brennan did with the holes in the sweatshirt, et cetera, et cetera. Thank you guys for being here. Make sure everybody hits that like button. Make sure you guys get in the chat. Make sure you talk it up. I'm going to do my best. How's it going to go? I don't know, but we're going to get through it. We're going to talk about this case. We're almost done. We've got closing arguments early in the morning. Let's get to the intro. So, chat. One of the things with this program is John said my mic might not be muted, and I just screamed to him. The chat is super slow on my end, so I'm probably going to be a little bit behind on the chat, just so everybody knows. So just, be ready for this kind of thing. Just like how it took me a second because it was a pause. I didn't know if it was going to come back to my face or what after the intro. And here we go. We are here, and we are going to talk about the proposed jury instructions. And what I'm going to do, since we don't know what the actual instructions are from the judge at this point, and there were so many that she said she's going to take care of, trust me. And I could just tell from the lawyers, they're like, I'll tell you how we deal with that and what we do with that. John, also, there's a bunch of chats coming through that are blank, like with no text in them at all. So make sure you're pinning questions and things like that, and I'll try to look at them. But so we're going to start out. We're going to listen to, and just let me know what you hear. If there are issues, we'll deal with it the best that we can, but just bear with us. Because again, I've never used this program before. We are going to listen to some of the discussions by the lawyers. Some of it is hard to hear, but that's okay. I'll repeat a bunch of the important stuff. We'll listen to some of what the judge said, and talk about why the lawyers are doing this. We'll break down a lot of the arguments, and I will still read some of the proposed instructions to help give us context around what may or may not come in, because the judge doesn't have to adopt the language of either side. But I will tell you, I have had appellate arguments built around what we proposed as the jury instruction. If the court adopted something different, that could be an issue. We've also sent versions back and forth, and the defense has agreed to our version and then objected to it after the verdict because they didn't like the verdict that we got. And we said, appellate court, we sent it to them. They sent us back edits on other instructions, but not this instruction. So they waived their argument. So this can be a very, very important part of the case. This can be a very, very important part of the process fully. But it can also be an important part of the appellate process. So that's why it's going to be really important for us to get through these. John, I'm pinning them right now, but you guys are going to need to as I'm reading and watching this video at the same time. So, all right, let's get into some of this charge conference. We're not going to watch the entirety, but some clips.
Charge. So we'll start with the defendant's.
So, John, they're saying we are not streaming on YouTube right now. Can you confirm that that is wrong? I guess I can before we get into it. Let me see here. Give me a second. I just want to confirm that we are on YouTube. We are not streaming on YouTube right now, John. No, we're not. I can't find it. It says upcoming. We're not streaming on YouTube. I'm telling you. We're not. I'm looking at it on my phone. It says upcoming, and it's just spinning. I see you watching on YouTube right now. Yeah, we are. All right. I'll trust the chat. All right, chat. We're here. Let's go. Okay, let's get into it now.
Missing witness. request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions?
That's a big one. So we're going to stop right now and talk about that a little bit. They are withdrawing the missing witness instruction altogether. Why would they do that? So are they abandoning the argument that the Commonwealth did not call Proctor, Higgins, Albert, and therefore you should hold that against them? So because they're abandoning the instruction, it does not mean they're abandoning the argument. The instruction is something that the judge reads. And frankly, the instruction can actually be a little confusing. And as I read it again, and you go through, well, was this person called to this side? Were they more friendly to this side? Did they have facts that were material to this side? It can get a little confusing. And maybe the jury will think, well, I didn't check all those boxes, so maybe I'm not going to hold it against the Commonwealth because I don't feel like the defense checked all those boxes. Maybe the defense thought it feels like we have a little bit of a burden with the jury, and they didn't want to do that. And this, in conjunction with the fact that the defense is abandoning the third-party culprit instruction and defense on its own, they're still going to try to do the hybrid with the Bowden, and we'll talk about that when we get there. But to me, abandoning all that can simplify this case for the defense. Because instead of going with an argument that 30 people were involved in a conspiracy, including law enforcement, judges, prosecutors, politicians, teenagers, right, that were in the house, adults that were in the house of all ages, all getting together and being in this big conspiracy, instead of them trying to prove that, instead, they're throwing some shade. Some very obvious shade and some shade that nobody can really disagree with. But in addition to the shade, they're focusing on the fact that there was no collision. There's actually proof that there was no collision, and it is more likely to be a dog bite or scratches than it is coming from a broken taillight on the SUV. And to simplify and streamline the argument like that, to me, makes a lot of sense. And the defense is a lot of strategy, because if you go back and listen to Alan Jackson's opening statement, some of the stuff he talks about, 2:27 a.m. Google search, we're going to prove this to you, Proctor's a cancer, you'll see. They've proved it in ways that they didn't prove it in trial number 1. With cross-examination, without confusing experts that maybe weren't that great, without giving some of these lay witnesses an opportunity to explain themselves, and you keep the boogeyman out there, and it becomes a situation where it's actually easier for the defense to make sure that the jurors are not confused by any of these instructions. Do judges have advisory counsel? Does Bev have one admonishing her for her behavior in one-sided rulings? They don't have advisory counsel. Sometimes they have law clerks. Sometimes they have committees that will oversee, like a judicial oversight committee that will oversee what they do. And if there's an issue, they'll step in. Peter, I'm always on the rewatch crew. Love the channel. Brennan's demeanor is off-putting. The investigation sunk this case from the jump. I got our Lawyer You Know merch today. So excited to wear them around. Thanks for all you do. We love hearing your opinion and learning from you. Having a type A meltdown, I know it well. You're good, sir. It's just who I am, okay? I'll continue to deal with my personal struggles and how I am, but we'll deal with it, and we'll continue fighting the good fight, and you guys make it awesome. Thanks for showing up and still hanging out. Do you or the chat think J.O. slipped and fell because he was drunk? If science can prove he wasn't hit by the Lexus, I think it's an option, and at the end of the day with this case, I'm never really going to tell you this is what happened, because I truly think I don't know, and I think I will never know because the investigation was so bad. I don't know how to hide this comment now that it's up. Okay, thank you. Okay, let's listen to a little more of this.
You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi.
Your Honor, if it's up to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instruction?
And that happens at the end of the argument. We are going to listen to that.
Of the law, right?
Yes.
All right, so model homicide instructions and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand this, the court commission might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking instruction on third prong.
All right, so we will deal with that. I'm going to go through the defendant's instruction.
Yeah, A-Lane, there's also just happens to be a thunderstorm that's going to be over in 30 minutes, but it's just dumping on us right now and just crashing lightning and thunder behind us. But
Are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction and proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So I will.
so that's the issue with if it is not guilty on one and not the other, how confusing all of that was the first trial. Well, the defense spelled it out this time. Hold on. No, don't put them up yet. Okay, hide it, but star it. Okay, just hide it and star it. Are you hiding it? Okay. Oh my goodness. All right, I started it. I got it. Okay. All right, there we go. Okay, so let me now, I forgot how to switch. Oh, switch. Okay, replace screen share. I don't know if this is the right one, but we will figure it out together, folks. Okay, so we're going to take a look at what the defense proposed here, okay? Because number one, Judge Cannoni's like, my presumption of innocence is better than yours, so I am going to read my presumption of innocence. Then she says, I am going to read the way I want to do this, but I'm going to make it crystal clear. Crystal clear is great. The problem is, she followed up saying she's going to make it crystal clear by saying, I believe I was the first trial and I was upheld. That doesn't make me feel real good, right? If she thinks she did it good enough the first trial because it was upheld, that doesn't make me feel good. I actually liked the way, shocker, the defendants drafted their proposed instruction. Ashley said, does it feel like day one of streaming? It feels like day negative because now I actually have some version of what I think it is in my head, and anything that's different makes me crumble. Okay, let's read this reaching a verdict. By the way, it would help me out if you guys would all hit the like button. I appreciate that. You're tiny, 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 somebody said. All right, is this better? This is our other option in this format. Okay, reaching a verdict. This is what the defense proposed that Judge Cannoni basically said no to, but she said, I understand why you want to do this, and trust me, I will make it crystal clear. Here's what the defense wanted her to read to this jury. For each charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. You may not find the defendant guilty on any charge just because you think the defendant did something else that was wrong or improper, a la drink and drive. Your decision as to each charge must be unanimous, meaning all 12 deliberating jurors must agree. I like how they spelled it out. This defense team has learned from us, we, the people, the public, the chat. I have learned. When I'm writing jury instructions now, I want to over-explain because it's a difficult job for jurors who are not professional jurors, who have never done this before, and I want to make sure they understand as much as possible. This is a crash course in being a juror. Must be unanimous. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink, meaning each individual document for the verdict. You need to go through it, vote, check the box, sign the bottom. For each charge, I know I was muted. I was talking to John. Okay. For each charge, if you all agree the Commonwealth has proved every element of that charge beyond a reasonable doubt, then you should find that Miss Reed is guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. I don't understand why you wouldn't want to read that. To me, that seems like a very good explanation. That seems like something the judge would want. Sorry, if you hear me mute, it's probably because I'm talking to John. I think that spells it out. That is as clear as possible. And I don't know why Judge Cannoni wouldn't want to read that, personally. But she is going to do it her way, and she's very confident her way is good because it didn't get overturned. To me, that's a pretty low bar, that you only change something if you get overturned. So we're going to reference these documents more, but I'm going to jump back now. We're going to listen to some more of the arguments with the lawyers about these instructions. Can you guys see you can't see the whole screen this way, so I'm just going to do this.
We'll make it crystal clear. Okay, so I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will.
By the way, if you guys have questions about a specific proposed instruction that you want to talk about, let me know in the chat. And if you guys, if there's enough people that want to hear about a specific instruction, I can read that. We can talk about it. We can answer questions as well.
Certainly cover all these topics. So, Mr. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowdoin. I'm going to take a look, size this up with what I gave last year.
She says, I'm going to give you Bowdoin, which we're going to read here in a second. But Mr. Lally wants to be heard on Bowdoin. He does not necessarily agree that they should be given Bowdoin, and they have an argument about it. So we're going to listen to some of their argument, and then we are going to read the proposed jury instructions that the defense has on Bowdoin.
I gave Bowdoin last year. I gave a Bowdoin instruction. I don't think the Commonwealth objects, right?
We would object to the instructions.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowdoin, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth will be making a similar request that counsel be prohibited from making a third-party culprit or Bowdoin argument.
Or Bowdoin? Or Bowdoin?
I'm sorry?
You don't think the defense should be allowed to make a Bowdoin to argue Bowdoin?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowdoin or third-party culprit in this trial has come from questions from defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence or anything of the like. So in the instruction and arguments are based or predicated in the case law on evidence. Obviously, the court is well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth will submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only Bowdoin or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowdoin is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so
Basically, his objection is he doesn't want him to go too far on third-party culprit. He understands there's a combination of third-party culprit and Bowdoin, and we'll talk about that. Yannetti's going to argue that. I also just want to say, if a super chat comes up on the screen and drops down, it's because it was accidentally clicked, probably. But we'll make sure they all get up there, and I'll talk through a lot of them, answer a bunch of questions as always. ABC123, John, this is a love letter from the chat. Thank you for making the lives possible. It's obvious Peter can't handle a glitch. It's 100% possible. Obvious. And John set up this whole whatever we're doing right now. It's not StreamYard, but whatever this is, so that we could even stream this way, because we were probably just not going to do super chats and I was just going to play the video. But we're able to play the video, read all the comments, read all the proposed jury instructions, because John was able to set it up in the background, which is awesome. And yes, IT support. John's IT support is in full effect here.
Disagree with you on Bowden, but I'll take a closer look at it. Mr. Yannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to package evidence. Chain of custody was contaminated and corrupted. There was evidence of bias. The lead investigator failure to pursue the suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just want to briefly to Mr. Lowry's comments about how he introduced affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about in an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were
I think what Mr. Lally was saying, that you asked questions but weren't given answers, and so I think that's what was said. I'm going to Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
Okay, hold on. Before we get to that, she's making a good distinction there. So first off, he says Bowden was very clear. And the fact that Lally said we have no direct evidence, he took that as an opportunity to say, we tried to bring in Mr. Easter to exactly show what the problem was with this investigation, and you didn't let us. So again, sword and shield, Commonwealth doesn't really understand how this works. Actually, the judge is the one who doesn't understand how this works. Commonwealth can try to do what they want to do, right? They can say sword and shield, that's how we're going to play. So from my perspective, the frustrating part is the fact that the judge could not possibly block this instruction for a lack of direct evidence when she didn't let them. What he's actually saying is, Lally's saying, it came out through questions, and questions are not evidence. So just because the defense asked questions, they can't use that. First off, that's just not true. The judge is not going to agree with that. The defense is absolutely going to be able to talk about Bowden. Now, how are they going to be able to hybrid and mix together Bowden and third-party culprit? That's what Judge Cannoni's trying to figure out here, because if you do it the Bowden way, it's this investigation was so bad that we can never prove who did it. Therefore, we're not going to sit here as the defense and try to prove to you it was Higgins, it was Albert, it was somebody else, which is what I think they should have done all along. And I begged them to do after the first trial and during the first trial. And to me, that's always been the better argument. But if you do that, you don't get the third-party culprit instruction where they can say, here's the evidence. We proved to you Brian Albert is guilty of this crime, or Brian Higgins is guilty of this crime. They're not going to be able to do that without that instruction. To me, it couldn't be clearer. The hybrid they should absolutely be able to do, Bowden and the third-party culprit mixed in. They're abandoning the standalone third-party culprit.
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. Correct. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand that.
So she threw out stuff like they don't have motive, et cetera, et cetera. Okay. And I want to be clear. They should still absolutely be able to say the cops had the waterfall video. You can see in the waterfall video, Higgins sees John O'Keefe kiss Karen Reed on the forehead. They see the video where Higgins is roughhousing. They see the video where they're together and then he motions, whatever. They had Higgins' text messages. They knew about the conversations between Higgins and Karen Reed. And what did they do? Nothing. They didn't investigate it. They didn't try to see if he had any culpability or if he had any more of a motive or if he had the opportunity to do it. They did squadoosh. Nothing, because the investigation was so bad. That's how you argue it within Bowdoin. It's not that you can't argue Brian Higgins might be the guy. You can't argue here's all the evidence that proves Higgins is the guy that did this. So it's a nuanced difference, but it's very important. Very, very important.
Distinction, Your Honor, and we're strictly going with a Bowdoin defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I would say from this clarification based on the
Yeah. So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give... Sure, go ahead.
Just while we're on page 8, I just wanted to, Alma does have an objection to the teaching of the teacher instruction. That's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Gianetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DPUT.
All right. So before we get to that, let me jump to, sorry, it takes a second because I got to still stay used to this or get used to this. Oh no, I think it's this one. Okay. So they're referencing page 8. They're referencing the Bowdoin defense on page 8. And so I want to read that for you guys so you guys can be tracking with what they were just talking about and what they're going to continue to talk about. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. That line right there, if I'm Jackson, this is something I'm highlighting, I'm putting up on the board, I'm repeating to the jury, this couldn't be better for this case. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on the circumstances. The prior statements is what they're talking about, statements being recorded or not. But that's the Bowdoin defense. How good is that? How good is that for the defense? From my perspective, this is the prototypical case for multiple of these jury instructions, and this is one of them. And they're going to have the judge tell them. And it is very important when the judge tells you, hey, if you find this investigation was bad, if you find that they didn't do proper testing that they should have, including scientific testing, if you find they did not do enough to prove this case beyond a reasonable doubt, that can be a reasonable doubt. You can consider that. I think it's a perfect instruction for them. And I think it's a perfect case for them. I think if they would have had Michael Easter, it would have been even better. All right, so now let's get back to the video.
Argument that we would have did not occur at a police station, but these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We have to rely on police.
I don't know if you guys can hear the house shaking thunder that's happening right now. It's crazy.
Memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to it.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Halley?
if I would also add, Your Honor,
Sure.
they did seize her vehicle around the same time. So, that it
People
goes.
are saying they can't hear it. They're just kind of arguing whether or not it was a custodial interview. They seized her vehicle. He's saying it is. They're talking about whether or not it should have been recorded, the conversation with Karen Reed. This is not, the most important part, but there's some other things that I do want to hear coming up here.
Initial custody and my client being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that day. They spoke to her while she was seated on the couch in her parents' living room, with her parents present, no one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle, based on information that they had developed over the course of the day, from statements from Ms. Reed herself. But I don't think that then transforms that conversation or interview in her parents' court. And that initially she said she wants to engage. It applies within the
Skipping through some of this.
Instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
not to interrupt.
that's okay. That's okay.
Ashley was asking about the custodial interrogation. So the prior statements says, when you consider whether you believe a witness or how much weight to give his or her testimony, you may consider whether the witness said or wrote something earlier that differs in any significant way from his or her present testimony in the courtroom. It is for you to say whether there is differences and how significant any difference is. Please note that you may not use witnesses' earlier statements as proof of something. So, for example, if a witness testified that he found a donut, but earlier had found a bagel, the earlier statement would not prove he found a bagel, but it might raise doubt as to whether or not he found a donut. The earlier statement brought to your attention is the sole purpose for discrediting the witness. I thought that this is where they said recorded. Here's the point. They're just basically arguing whether or not it was a custodial interview, whether or not she should have been read certain rights, and the police are supposed to record under their processes and procedures. They're supposed to record an interview like that. It wasn't perfectly drawn out because we didn't have somebody like Easter to go through exactly what did or didn't happen according to police procedure in this case, but that's why they were arguing it. DD Girl said, my super chat was not read. I'm doing my absolute best. Okay. Doing my absolute best, but just so everybody knows and everybody understands, this is not going to be a perfect technical stream where every single thing is done the perfect way. So keep that in mind. And any comments you made, super chats you make, anything you do, just be aware. Okay. I'm doing the best I can. Is it usual for a prosecutor to skip rebuttal when the defendant presented a case like this? Absolutely not. Especially when the judge gave you so much leeway on rebuttal, especially with Welcher. Your $400,000 expert should have come and hit an absolute home run in rebuttal. Completely abnormal. This is not something that's normal. Why wouldn't the Commonwealth want the guilty, not guilty from the crystal form to be crystal clear for the jurors? Just don't get it. I don't think they objected. I don't think they don't want it to be crystal clear. They just almost always have to object to how the defense words something, right? And vice versa. They want it to be crystal clear, I think, too. I don't think they want it to be confusing on that. Some other things I think they might want to be confusing, but not that. What's the new format? Might have missed it earlier. I have no idea what it's called. I just know it's different than what we've ever used before. Does the Commonwealth get two closing arguments? Yes. Because they have the burden, they get first close and last close. It's called a rebuttal closing. But that's in every case around the country. That's how it works. Peter, should the defense recall Maureen Hartnett to ask about the hoodie? And if she prepped with the Commonwealth in regard to those holes? They can't. And I don't think they need to. I think Alessi fights for a very good instruction. At the end of this video, we're going to watch it. And that's really important. Do paralegals still summarize depots or all AI? We have done both, but I still like to read the whole depot, especially if I'm prepping for trial and I need to get cites anyways. I need to get page and line numbers, so I might as well read it myself. But I like paralegals better than AI because I can talk to them about it as well. Why didn't she let Dr. Rentschler's PowerPoint in, but she did let Dr. Wolf's in? Peter, I'll send you some magnesium and lemon balm tea. Yeah, this is left over from the concert. I thought there was inadmissible things in every single PowerPoint, and basically, I think the defense thought there was a gentleman's agreement, but when the Commonwealth objected, the judge is like, well, you didn't object, and now they're objecting, so it's out. That seems to be the basis, because there were hearsay and some inadmissible things, which, again, I think there's been multiple PowerPoints, but that's why she said she made that decision. Okay, let's listen to some more of this.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked her to repeat that 1 sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a
Judges want to do that sometimes, and we as lawyers even sometimes do. I've flipped on that. And I think it's YouTube that has made me flip on that. Talking to you guys, the chat, hearing juror interviews afterwards, like so much of the information I've gathered here, I don't care if they have to sit there for an extra 20 minutes listening to these boring instructions. I'd rather try to make it as clear as possible for them. Over-explain. And from my perspective, let's make sure the jurors know what's going on.
shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that, without
Sure.
any language in there, I would object to it.
Okay.
That's what a police officer or someone else who works for a law enforcement agency.
What do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be possible.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as photographs, I-
What page you want?
16.
Okay.
One suggestion there was, in case, now, Commonwealth has introduced photographs and evidence, I would submit.
Yeah, I'm just going to,
They're talking about photographs and evidence. We don't need to listen to that one. We'll listen to the dangerous weapons. Car as a dangerous weapon.
motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Tianetti, what do you think about the short instruction on jurors? Sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay.
By the way, some people said you mean dumb it down, Peter. I really don't mean dumb it down. I really mean over-explain in layman's terms. Here's the reason. It's not like judges and lawyers want to speed through it because it's not important and they don't really care. They want to try to simplify it because that's what lawyers do, right? We take something big, we simplify it. We like to cut it down. Word limits. There's lots of word limits on documents and things you can file. There's word limits in law school. Learn how to say what you need to say in less words. That is something a lawyer really should be able to do. But I honestly think sometimes we do this as trial lawyers, if I can be completely transparent, because we don't think the jury listens. We think the jury's glazed over. They don't care what judges say. And I think they do listen. And I think when it's so important and there's this many important instructions, you just got to get through them and do it fully.
Thank you. Charts and summaries, I'll talk a little bit about chalks.
Okay.
And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it, witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely.
So that I thought was a good one. And I don't need to put it up on the screen to read it to you, but this is something that, who put this in? Where is this? Yeah, the Commonwealth put this in. Okay, so this is in the Commonwealth's proposed instruction. Witness pretrial preparation. There was testimony at trial that the attorneys interviewed witnesses when preparing and during the course of the trial. Preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview a witness. Isn't that something that Brennan is the one that put these in his proposed jury instructions? When he's the one that made it seem so nefarious? If they had talked to witnesses, And I think he's going to argue that. Now, the judge talk about there is a difference between prepping a witness before the trial and during trial because of the sequestration order. But I thought that was very interesting that Hank Brennan's the one that proposed that.
From that fact, there is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right.
The defense is like, listen, Judge, we're good with it. We like that request too. Because they're the ones that Hank Brennan tried to look bad. Hank Brennan tried to make them look bad all trial. So Yanetti's like, you know what, Judge? We have no objection to that one. And if the two lawyers have no objection, Judge, can you just chill and read it? We both think it's appropriate. Go ahead and read it. We've waived our appellate issues on this.
Okay. Expert witnesses, electronic communication. So I'm going to go through
We've heard that one a million times.
Aruba incident, if you want to call it that. I gave instruction. I did that in regard to the Aruba incident, if you want to call it that.
Prior bad acts, she's going to give an instruction on it because of Aruba. And you may think, we didn't really hear anything about Aruba. Well, the judge lets the cat out of the bag here.
I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
You're right, we're looking at two Aruba. We don't believe that there was really any testimony that came in.
I thought it came
Nettie's like, I don't think Aruba came in. You can't hear him. It sounds like he's underwater, but here's the judge's response.
in through Kaylee. I should say it did come in through Kaylee.
It did come in through Kaylee, John's minor niece, that we did not watch. So we might not have known. We don't know really what all came out through Kaylee. The judge confirms that here.
That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right. I'm going to take a look at that, Mr. Alessi. All right. Consciousness of guilt. Okay.
Consciousness of guilt withdrawn from the Commonwealth. That's what he said. Let's listen to it one more time.
All right. Consciousness of guilt. Okay. All right.
So isn't that interesting? They withdrew it. Thank you, Amy. Yeah, I agree with this. We're going to listen to a little bit, then we're going to read that instruction.
All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Okay, so we're going to read that in a second. Whether or not she should read the model instruction or this, we're going to read what it looks like and talk about that. But first, I'm going to read the consciousness of guilt instruction here. That's the right one. I think this is it. Okay. So this is what the Commonwealth put in their proposed instructions. They withdrew it. So they're not going to be using this. You have heard evidence suggesting that the defendant may have intentionally tried to destroy, conceal, or falsify evidence in this case, and may have intentionally attempted to harass and intimidate witnesses whom the defendant believed would testify against her. Does that ring any bells that the Commonwealth tried to do this? If the Commonwealth has proved that the defendant did, you may consider whether such actions indicate feelings of guilt by the defendant and whether, in turn, such feelings of guilt might tend to show actual guilt on these charges. So like I said, it was very obvious this was going to be a theme of the Commonwealth, and they wanted the judge to instruct the jury on it. Now they've withdrawn that. That doesn't mean they're not going to argue it with Dever, with Lucky Laughlin, with multiple witnesses that took the stand. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations, along with other evidence. I caution you in considering such evidence that the defendant is not on trial for destruction of evidence, misleading a police investigation, or witness intimidation, and you are not to consider such evidence as a substitute for proof of guilt of the offense with which the defense is charged. You may use such evidence only for the purpose I have instructed you, that is, whether it shows consciousness of guilt for the crime charged. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all of the other evidence. So Elizabeth is asking about a poll. We did a poll yesterday. It was like 88% not guilty. I want to say 5 to 10% either guilty or guilty of a lesser included, and the rest hung jury. But what do you think about that consciousness of guilt instruction? Right? It's like, well, we're not saying you should vote guilty about this, but you should vote guilty if you feel this way. Not coming in. The judge is not going to instruct the jury. I do think Hank Brennan is going to argue something very similar to this to the jury. All right, now let's get to the actual second degree charge, right? In order to prove this, the Commonwealth must prove the following elements. The defendant caused the death of John O'Keefe. That's obviously important. The defendant, and the Commonwealth is saying we don't want you to read these two prongs to the jury. Intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe. Because they're basically saying, and Hank Brennan said it in opening, we don't think she necessarily intended to do this, but we don't have to prove that to win on second degree, which I think was smart. Instead, they just want the third prong read. That she intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So she intended to drive drunk backwards at 24 miles an hour, knowing that the death of John O'Keefe would likely result. And that mens rea, that mindset is important. And that's what differentiates all of these charges. Did they prove it? I'm going to jump down now to manslaughter while operating a motor vehicle. They must prove 5 elements. First, that the defendant operated a motor vehicle. I think they did that. Second, that she operated a motor vehicle upon a public way or in a place which the public has the right of access. I think they did that. While driving or operating the motor vehicle, she was under the influence of intoxicating liquor and or percent of alcohol in the defendant's blood was 0.08 or greater. I think they could, some people may disagree. I think they proved that. Fourth, that the defendant operated the vehicle in a wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. So that is what's different than second degree. That's also what's different than involuntary manslaughter, which is just kind of, she operated it negligently. And that is something that I think juror to juror, did she prove they did that? Sorry, did they prove she did that? Or did the Commonwealth not prove Karen Reed did that? And then fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. And this is where people argued, well, if she didn't come into contact, but he had to jump out of the way, slipped and fell and hit his head, or that he spun out of the way, slipped and fell and hit his head, you could still argue her driving the motor vehicle that way still caused his death. But that's not what the Commonwealth argued. And that would be completely inconsistent with all the Commonwealth's evidence. So logically, I don't think you can get there if there was no impact. I think you have to find an impact if you're this jury because of the way the Commonwealth put forth and presented their case. And so I wanted to read those instructions so you could see the difference between second degree and this one. And then leaving the scene of the accident. First, the defendant operated a motor vehicle, that she operated in a public way, that the defendant knowingly collided with John O'Keefe, and that the collision caused the injury to John O'Keefe, resulting in death, After causing such injury, the defendant failed to stop, provide name, home address, and registration number, and that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. And that's kind of why John O'Keefe was alive and laying there and she still decided to leave. A lot of those arguments could have gone to this one. Okay, so I wanted to read those so you guys kind of see the difference. And then we're going to jump ahead a little bit in the video and get back to the video now. Hopefully you guys are all following. Whenever I read, it is so hard to continue to follow the chat. Let me hit some super chat questions here. If Lawley and Judge are not held accountable despite unethical or ethical misconduct, what does this mean for interactions between Lawley, or do you mean, sorry, I thought you were saying Lawley, lawyer and judge themselves? I don't know what this question is asking. There can be problems that happen for them afterwards, or they can go on just continuing to practice, which is probably likely what's going to happen. How quickly do you expect the jury to come back? If it wasn't for the last trial, I would say end of day, Monday, maybe Tuesday. She absolutely makes it clear she wants them to be able to start deliberating Friday before they go home, and she's going to let them stay past 5 o'clock. She wants to have that happen on Friday. So normal, I would say they would start on Friday, take the full day Monday, and either Monday night or early Tuesday, I would expect it, but because of the last trial, it's probably going to be longer than that. Did the Commonwealth standalone DUI charge? No. I kept thinking, how do you keep this from becoming a whodunit versus did Karen Read do it when trying to prove conspiracy, proctor, third party? I think they avoided that so far. I hope they keep it up. I agree. Did they add a charge for drinking and driving only? No. Why is Lally the only one talking today? He is handling the jury instructions, and it doesn't really surprise me. He's been with this case longer. This is kind of simple stuff, and the judge is going to do what they want to do, and he's probably met with Brennan and talked through this. Even though Brennan is a better lawyer, do you think Lally had a better strategy, calling everyone kind of force the defense to focus on the conspiracy? So I don't remember where I said this. It may have been with Ted Daniel today. But I actually think if we look back, as crazy as it sounds, Lally calling 1 million witnesses makes it seem like 1 million people thought Karen Read is guilty. And I'm saying 1 million, obviously being hyperbolic. All the people now say John O'Keefe never came in. All the people now say they didn't see X, Y, and Z. All the people now said they talked to each other. There was no conspiracy. They didn't talk about it afterwards. Nobody told them to hide anything. All the people saw it the same way. All the cops he saw felt like Karen Read was guilty. This time, only a couple people inside the house. Only a couple cops were called that believed Karen Read is guilty or didn't like Karen Read. So the jury does not have to believe all these people were involved in anything in this case. And did that actually help the defense? Young kids, older adults, council members, cops, commissioners, right? You tell me. And it was snowing and it was this time and all that consistency, even though it was unimportant, did it help paint a clearer picture? Will the defense see the juror bingo ball drawing? I don't know how they do it. I've never had them do it like that, so I don't really know what they see and what they don't see. Curious your thoughts on why Lally did all this. It's not abnormal for co-counsel to handle something like this. I never handle this, ever, when I try a case. Ever. Never once have I handled this. I'm listening and paying attention, and I've stepped in and made arguments and argued about things, absolutely. But usually, like Pete Sardis is really good at this. Really good at this. Even the last trial I had, he didn't try it with me. On the phone back at the office, he was putting together our proposed instructions. And because of that, he's a witness in the appeal now. Why wouldn't Bev want the instructions to be clear? I think she does, but she just doesn't want to waste time. Who needs mod when you have the GOAT, John, behind you? Thank you, sir. Peter, what do you think she will change to be more robust than the defense's version? I don't know, but I will tell you what. I think this defense will, and I think they absolutely should read every single word before the judge reads it. Before there's an agreement, everybody needs to know what exactly will be said. It's not just like, trust me, I'm a judge. No, judge. We want to have a say in this. And if you're going to deny what we want that on the record. Will they get instructions in writing? Also, absolutely, there should be multiple sets of every instruction so everybody can read through them before they read them to the jury. Do you think Gang Brennan will do closing arguments? Absolutely. Are you surprised they aren't contesting the SUV reversal event? Will the jurors think that John O'Keefe's phone activity ending within seconds is too coincidental? That's some of the best arguments for the Commonwealth. But I think the defense is going to focus on the science, the medicine, the taillight, the crash dummies, the scratches, the dog stuff. That's what I think they're going to focus on. Pita, what are your thoughts on Karen getting her life back on track after acquittal? What happens after clients lose everything when they win? Well, you see Johnny Depp, it was hard for him, but he was able to have a positive bounce back. I think because of the public push and kind of fame Karen Reed has gotten, it's possible for a positive rebound. Maybe she goes to law school, right? Maybe she becomes a lawyer. Maybe she works for one of these lawyers. Can you cover what kind of sentences these charges would carry? Yes, we usually do this during deliberation or post-verdict. Your opinion, do you highlight all the I don't know, I don't recall from the prosecution witnesses in the beginning, middle, or end, or not at all? I would probably weave them in with how incompetent the investigation was and how they didn't do all this scientific testing that they should have done. I would weave it in. It would not be its own part. They could be watching from somewhere else. That wouldn't be weird at all. Like I said, Pete a lot of times is in the office helping me with these. Okay, we're going to jump ahead a little bit to the next set of arguments. This is when they start talking about the verdict slip.
Sorry.
So you'll recall.
I'll hear you.
I'm actually in a
Kind of a funny moment. She calls Yannetti Alessi.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in a
Yannetti, jeez, I'm sorry.
So you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next, until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, the court probably well.
This is him again trying to explain how we can simplify it, make it easier for the jury to understand what exactly to do. I saw somebody say the defense asked for an OUI. That would be a smart thing, because that would be something that would give them a split the baby option that she would be convicted of that would not have the effect near what any of these charges would.
Where the Commonwealth not requesting any lesser included, and I certainly understand that if the evidence supports the defense requested, that the court must give it. Having said that, the verdict slip reduced in this matter last year. Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Olao, in which he had similar issues and had, I believe, use at least part of the verdict slip from the first trial, in this case, as sort of template for the lesser included that he instructed and the verdict slip that they utilized and acted. I don't have a copy of it on me, but I can certainly get the court copy with a copy of the docket, but that may be somewhat helpful with the court's thinking about it.
Okay, was that on murder case?
It was not, but it had to do with the felony motive homicide.
Okay. Yeah, I'll take a look at it. Mr. Turk. Mr. Turk.
All right, good question. People said, what's an OUI? Operating under the influence. It's like a DUI in your state, or DWI. Different states call it different things, but it's basically a DUI, driving under the influence of alcohol.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lell is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that.
It's really frustrating. We had the problem in the first case. We have the opportunity to give a better verdict slip. This time, the defense actually did write it out and spell it out to simplify it for everybody. And it sounds like the judge is going to deny it. So incredibly frustrating.
And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy?
sure.
This is the-
Yes. Or, you know what, just mark it for identification, Margaret. We'll do.
I just, one request, circling back to the constitutional field instructions. So Commonwealth is withdrawing his request for the instruction.
Okay.
However, would be seeking to make some argument or reference in his argument to the jury related to specific areas which we would need judicial approval before we did this. So the two areas that are sort of listed within that, if you'd like to make some arguments to the jury regarding, is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips of the play for statements.
Okay.
In particular, would be the one where essentially she says it's that came to her.
Okay. All right. Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence.
First off, you absolutely can do that if there is evidence of coming in. We'll listen to the arguments, but you don't have to have the instruction in order to make the argument. That's what they were trying to clarify. The defense is going to do the same thing on some of this.
That the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, "Yes, come on over." I don't see that as being any evidence of consciousness.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just
That's the correct ruling, in my opinion.
to be further clear, there may be other clips of
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay.
do not like it.
Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti?
Right, we're going to jump to the next section, but before we do, let's answer some questions. I really want you to read the missing witness instruction. If you guys want me to read that instruction, let me know in the chat now. Just type missing witness instruction. Since we have a vote for that, I will put it down on my sheet. And if people want to read that, I will read that a little later. Does the jurors get a copy of the instructions as well as hear Auntie Bev say them? Yes. And they get to take the instructions back with them so they can reference them. What's the deal with Lally speaking today and no peeps from Brennan? Not complaining. It was refreshing not to hear Brennan snark. It's very normal for lawyers to split this stuff up. Have you ever used a legal nurse consultant on a case? Any advice on how to market myself to my experience in front of attorneys? Thank you for all your honest opinions on cases. We use legal nurses on nursing home negligence cases the most. That's where they've been best suited for us. So maybe if you have experience there, that would be good. Is number 4 not covered by driving drunk? Sorry, I should have read this with the jury instruction up there. No, not necessarily. Not necessarily, but that can be very good. In order to get justice for John O'Keefe, do you think that not only will Karen Reed be found not guilty on all counts, but Higgins, Albert, McCabe will be charged? This case has raised a lot of suspicion. No, I would be absolutely shocked if somebody else in that group got charged. I think she was intoxicated. Question is when. We heard testimony to defense. She seemed fine. Who's to say she didn't get to John's house and drink more? Commonwealth's arguing that, but why can't it just be as easy as guilty or not guilty if she hit him or not? I don't understand how this works. Well, it depends on what her mindset was. If the jury thinks she hated him, she wanted to do this, or if it really was a DUI accident, the punishments are very different, so it does matter. Do you think Alessi will be closing? He should. I think Jackson's going to be closing, but I don't know for sure. Rolling in late, not sure if you covered this. Do you think it was weird Hank Brennan didn't do the argument in response to Alessi? No. And frankly, sometimes it's better when they're talking about a screw up you did for another lawyer on your team to make that argument. Did I miss why Lally is arguing this? Also, no Jackson. It's not abnormal at all. Sometimes, frankly, the guys that are better at presenting in court and better at maybe an opening statement or closing argument are not as good as arguing things like this. That happens a lot. People have different skills. How come Lally was the only mouthpiece today? So a lot of those questions. Do you think How's Long to Die will be a topic? I'm sure they'll talk about how it's perfect in the timeline and it proves, all this shadiness with the Commonwealth, but I don't think it's going to be as big of a point as it was in opening, and definitely not as big as last trial. I think the Commonwealth withdrew the consciousness of guilt instruction because they didn't want to remind the jury of Dr. Russell's acute grief response. By that standard, would not all deaths that are a result of DUI become second-degree M's because the driver knowingly increased the situation that could cause death? So just because you're driving drunk doesn't necessarily mean it's going to get in there, but I get what you're saying, and it can be an argument there, but there's still more intentionality to it. In closing, is it a mistake for the defendant to say there was no collision, but even if there was, it's assumed it is, it's more likely that a dog person knocked him down and killed him 2 layers reasonable? I would not argue that at all. I would never say it's even possible for a collision because all the science, all the data that they presented to the jury said, no way it was a collision. We think it was probably an animal or a dog. All right, the next section we're going to listen to is, the next section is getting into, I'm going to answer some more questions before we get that because we're kind of changing gears, getting to the updated instruction Alessi wants. What I meant by my question was whether lawyers or judges who behave so unethically are at least shunned or excluded within their professional circles. Is this such a thing as a code of honor? Yes, clients can care, other lawyers can care, judges can care. We've had judges who end up leaving the bench after high-profile trials that people did not think they did a good job at. You just said Commonwealth has closing twice. How long the second one? So they're combined. She's going to give them an hour and 15 minutes. The Commonwealth's combined 2 closings, they only have an hour and 15 minutes total. If the Commonwealth withdraws conscious of guilt, they can't replay Karen Reed's interviews in closing or all these different things. No, they can absolutely still play them and they can absolutely still argue it. The judge just won't instruct. Peter, you and 99% of the chat assume not guilty verdict. If I'm right, she is found guilty. Will you agree to wear a Ben was right t-shirt for one video? Absolutely not. Number one. Number two, I am not 99% think it's not guilty. I would not say I'm that confident at all. I would say closer to 60%. I think there's a 60% chance at a not guilty verdict. I think there's a 5 to 10% chance at a hung jury and maybe a 30% chance on a, if she's guilty of second degree, I will be pretty surprised, I will admit. But in one of the manslaughter charges, I will not be shocked. I would not be shocked. I put it at about a 30% chance. I know how this stuff works, and I know how most jurors walk into these cases. But I get you were doing it all in fun, Ben. And I will say, Ben, I am so glad you are here because you represent that 30%, and just in my estimation and mind, that chance that there still is a guilty verdict. You and John O'Rourke and the people that are still explaining, I still see that you are saying that you still see it as a guilty verdict. And I think there's a chance that some jurors feel that way too. My guest to the side conversation you're having right now, Peter, you left the toilet seat up again. I'm sorry, what happened again? No, very different than that. Seems like Brennan didn't show the sweatshirt as the defense would have objected before being presented at all. Bev didn't include most of what Brennan suggested. Hi from Canada, go Oilers. Yeah, some big things going on in hockey, huh? We're going to get to this as we get to this argument that's coming up. Peter, you're a great advisor on law. Was the straw in evidence black? Yes. She let the clear straw in the video and evidence to the last witness of the defense. Ooh, that's a detail I am not confident about at this point. Was the jury expecting rebuttal witnesses? No, they don't say like, oh, the Commonwealth can call rebuttal. Usually when there is a rebuttal case, the judge gives an instruction to explain it. Could the defense throw in FBI in regards to the McCabe lying, brushing her teeth? No, they're not going to be able to do that. Are new demonstrative aids allowed in closing to help summarize? Absolutely. PowerPoints, things like that. I mean, I shouldn't say absolutely in Bev's court. I don't know. Judge Canoni, excuse me. But usually, yes, you're allowed to use that. Peter, will you do a defense closing argument? I'm not going to be able to this year. This trial. AJ should start defining honor and integrity. That would be interesting. Can Bev message defense prosecution outside of court, texting, etc.? No, absolutely not. Email potentially if all of them are on it, but definitely not privately. Okay, let's jump ahead now in the video to the arguments Alessi makes. I'm going to skip some of his repetition and get to when he starts going into the colloquy and what happened with the instruction, with the holes in the sweatshirt, and what instruction he is asking for. And I think it's very interesting. He keeps referencing, we could ask for a lot more, Judge. And I agree with him. They could have asked for something all the way to what I was asking for. They asked for a little bit less.
Colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan...
Okay, so he is now about to read what the defense wants the judge to read to the jury as a curative instruction. How did Bev read charges instructions the first time? I'd have to go back and listen to it. I don't have it memorized what all she said.
It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes...
So, before he gets into what he wants the judge to say, I instruct you, the very important part of this instruction is that the Commonwealth falsely insinuated that those happened the night of the incident, of the alleged incident. That is the important part they want to put into this instruction. That is what I am going to keep an eye and ear on as to, does Judge Cannoni agree with that? My guess is no. But that is the important part. Yvette, I feel sick to my stomach that Peter thinks only a 60% chance of not guilty. I don't know, okay? I'll tell you, jurors are so, you can't predict what they're going to do, okay? I feel like it is a very easy not guilty vote for me at this point. I don't know what happened that night. I don't think we'll ever know, and I think that's mostly because of the horrible police investigation. But with the experts the defense called, I am very confident in a not guilty verdict for myself. I don't know how the juries are going to say that, so that's where those numbers kind of come in.
January 29, 2022, from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I...
All this other stuff aside, didn't I say the date? Pretty sure I said the date. I don't remember if she did or not. I'm sure you guys do.
did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th.
She's like, well, you asked for the date and I gave you the date, Mr. Alessi, and that was important. He's like, among other things, Judge. Among other things. So I had to put this up here. Ben and John always state their opinions with sound reasoning attached and never use ad hominem attacks against people in the chat. This is a refreshing way to have a conversation on the internet. I agree. Here's what I will say. I agree with this, number one. Number two, I used ad hominem in a game and everybody was like, you're making up words. I think it is spelled wrong here, but I could be wrong. But it was hilarious because I was like trying to define it to people. But yeah, I appreciate people that can disagree respectfully. That's what we've been trying to do. How common is it for a judge not to give lawyers final instructions before writing their closing arguments? They give them to us when they're ready, frankly. So what I'll do a lot of times is I'll have a couple. I may say this is a standard instruction. I may just wait and use the paper version or read it to the jury or put it up on the Elmo versus in a PowerPoint. I'm telling you, trial lawyers have to adapt. How would you address the clips in closing? I would say they're taken out of context and listen to what they say. It actually says X, Y, and Z, not what the Commonwealth is saying. And what it proves that's good for your case, like, gushing blood or glass, not plastic, whatever. Use them your way. Now, what I'd probably try to do is hours of interviews, and they play you these little snippets. It's very clear from these snippets they're cutting her off in the middle of words. Now, hours of interviews, probably not in evidence, but I'll say it's an inference I can make. Regardless of the verdict, do you think the FBI will reopen prosecute the prosecution side of all their liars? I just don't know. The FBI is also unpredictable. Heard Massachusetts Commonwealth closes once at the end, same first trial. Oh gosh, is that right? You might be right, and I may have been saying that wrong. You might be right that the defense goes first, the Commonwealth goes last. I can't remember from last trial. I've never tried a case like that, so that might be different in the Commonwealth. I'm not positive. But thank you for saying that. Let the record reflect. I am wrong plenty, and this I might be wrong about. The judge frustrates me on this issue. Her attitude that day was terrible, and today she tried to justify because they didn't object to something they were given an opportunity. To me, I would reprimand the other lawyer if I was a judge. Be like, come on. It was clear you guys were going to agree to this. Now you're going to go back. Now, I might say I still have to consider it, but defense attorney, I hope you know who you're dealing with now. Get everything in writing. Karen Reed not guilty on all charges. Do you feel like Karen Reed advocated for herself in court very well, i.e. future law career? My son and I have really bonded watching this. Thanks so much. I've seen a lot of parents and kids and spouses and siblings and friends bond over this, watch it together. I can't tell you how it warms my heart to see an Instagram post being like, hey, we're working out, watching Lawyer You Know together, or wine glasses, cheersing, saying, me and my husband finishing the night, winding, because I know I watch my shows and with my wife and we wind down at the end of the night when we're done with our kids. I love seeing that. I appreciate you guys so much. I think she's learning a lot. I think she's had some very good teachers on this defense team. I could see it. Would there be any benefit to Karen Reed if the defense used the Karen Reed clips, maybe argue against each to take the sting out, kind of like when Hank read Proctor's texts? I don't know how much I'd use them, but I'd definitely try to give context to them. There is a big difference in how we, the chat, and lawyers look at the law from what average citizens thinks about the law to I think you mean different viewpoints. I couldn't agree more, Kyrie. And I always try to point that out and focus on it. And people make it sound like I'm like speaking out of both sides of my mouth or something. It's like, no, this is reality. And this is how we should look at it. Peter is a lawyer. If you ask him for 100%, he's going to say it depends. Well, it usually does depend, Amy. It usually does. Touche. Right after I said it depends. Peter, maybe this has been answered, but I only caught the second trial. Will we hear the actual instructions Bev gives the jury? I'm assuming no. Yes. Usually they are live streaming. Usually you can watch that entirety if you want to. We will not be watching it together, though. We'll talk about it after. We're definitely going to talk about closing arguments tomorrow. We may even do our video while the jury instructions are being read, so you can maybe watch them after or whatever. But we will definitely talk about closing arguments tomorrow. I don't think we'll have a verdict tomorrow. If we do, we're going to go live for the verdict. So everybody, please hit that like button if you haven't already. Make sure you are subscribed to our page. Make sure you hit that reminder bell. If you want to watch the verdict live with us, we want you to be here. We'd love for you to be here and talk about it with us. If you watch it on rewatch, that's great too. If you're watching live with somewhere else, there's so many great creators and lawyers and people breaking this down. And I know you watch live with so many people, so it's awesome. I know you get the recaps here. We're going to do the live verdict watch and do some recap and discussion afterwards, answer questions. So we will be doing that. I'm also going to try to do some collaboration with Boston 25 and their local news. I'm not positive exactly how that's going to go. What just happened? Oh, does KR have to wait in jail if found guilty until the appeal happens? You're great. So they can file motions to let her out pending appeal. Usually Judge Cannone is the one making that decision on to whether or not she's going to be let out during the appeal. But I think she should absolutely be able to be let out during the appeal because there was already a hung jury. So there are issues with this case, no doubt. This should absolutely be one where she should be out on a bond. Okay, let's get back to Alessi's argument about this instruction he wants.
Right?
Yes, Your Honor.
Okay.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth.
We know why they don't want to support it. I agree it supports the truth. It's exactly what happened. But wait till you hear Lally's argument. This was just like mind-bogglingly bad argument by Lally.
We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not
I completely agree with him.
objected to at the time it came in.
That is just so stupid. That is a stupid, I don't want to call her stupid. The comment is stupid. The reasoning is stupid. All this stuff was happening so fast. You didn't give the instruction that you said you were going to give. By the end of the day, they asked you to fix it. It's like they're doing this as fast as they can. They're not going to object while you're in the middle of giving an instruction. So I hate when that happens, and she has used that so much. But I will tell you, as stupid as I may think it is, so many appeals are lost because defense attorneys do not protect the record with objections. So maybe I'm stupid, right? I hate that as an argument to be like, you missed your shot, because they tried to do it just, what was it, like an hour later?
That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider
it, but probably not.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
They didn't know. They didn't know. They can't know every single thing as immediately when it happens. And the evidence was up by the witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So
I will say, under that logic, they should have stood up and said, Judge, he didn't show us the exhibit or the piece of evidence before he showed it to the witness. They're allowed to get up and do that. They didn't do that, so they waived that too. So it's like, if you try to be a lawyer and you're sneaky and a snake, sometimes it can pay off. Like, we don't want that. We really don't want that in the courtroom. As somebody who I always want to go up against skilled, good lawyers, I think I was just texting Bettero about this. I was like, I prefer to go up against a very good lawyer. And you may be like, oh, that seems kind of stupid. Because in my opinion, most cases are won because of the facts. What happened? What can you prove? And when you go against good lawyers, that's usually the result, whether you win or whether you lose. But sneaky, underhanded lawyers you can't trust are the worst lawyers to try cases against.
So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
All right, before we get to Lally, let me hit a couple questions here. First, actually, before I get to the questions, I told my favorite scramble partner ever, sweet lefty swinging Timmy Sullivan, that I'd give a shout out to Lindsay, his wife, who's hooked on the case. Tim Sullivan was like my 13th subscriber. And yes, legitimately 13th subscriber. When there was like 6 people watching my very first lives that I did, he was one of those 6 people. And his son as well, who's an absolute superstar baseball player and also a stud on the flag football field as well. So shout to them and to little Remy, of course, too. All right, let me answer some questions here. Yeah, because your live verdict worked so great today. I mean, that's a shot, John. I mean, Cody takes a shot at our verdict for Lori Vallow. It wasn't the best technical one. It was awesome to see, he said. So hopefully our Karen Reed live stream will be better for the verdict. Most people liked it, okay? Go watch that video and hit the like button if you haven't. Maybe we'll keep it up. Why does she say we might have security issues? That's interesting. I don't know what she meant by that. Maybe if it's guilty and people go crazy and they have to make sure that they don't storm the courthouse. I don't know. Wait, did she get the DUI lesser included? I did not see that specifically. Hi, Peter. I look forward to your take on this trial. I finally learned how to send a super chat. Oh, so here's something else funny. Somebody emailed me and they're like, I'm 68 years old. I don't know how to subscribe. I want to subscribe. Can you do a video explaining to us? So I told John he needs to make like because they watch it on TV. So on how to subscribe and like a video on the TV. So we're considering that. Don't worry. People ask, we got to give the people what they want. Sorry, I was referring to the curative instruction on my last super chat. I hate autocorrect. It happens to the best of us. Wear pink tomorrow. Let's support Karen Reed. I appreciate how you try to be as unbiased as possible. Curious about your opinion on the jury nullification and if you've been on cases where that's been enacted. Yes, I actually have not. My dad has, and he's told me about it, but you cannot ask for it. You cannot ask for it. Didn't realize how much I distrusted experts until conspiracy theorist Dr. Rentschler. Common sense over all of them. Commonwealth goes first, last. They'll split up their 75 minutes. They'll end with her culpability clip again. Very guilty. Peter, you're not stupid, just your ideas. Thank you. Thank you for that backhanded compliment. So long ago, hard to remember, defense pounded some of the prosecution witnesses about talking to meetings within the witnesses, so it was not just Hank Brennan. Oh, I agree. I just felt like Hank Brennan did it way more. How did the judge see the shirt if she walks in on the left? I think she knew she can't see behind the wall. Sus. I'm not sure. But let's listen to this Lally argument, which I hated.
Very briefly,
Keep your voice up, please.
yes, very briefly. I'm not going to get into a belabored point as far as the back and forth about conduct of counsel. During the heated trial,
He's not going to get back and forth into the conduct of counsel. Why do you think that? Why do you think that? Why doesn't he want to go back and forth about the conduct of counsel in this instance? I think we all know.
the counsel. I'm not going to get into a belabored point as far as the back and forth about conduct of counsel. During the heated trial, during the heat of the extended exchange with the witness on stand, things can happen. Mistakes can be made.
Things can happen and mistakes can be made. Lally's like, it happens. Mistakes can be made. Not like that, they shouldn't.
Recognized, acknowledged, and accepted as a mistake. There were numerous offers.
It was acknowledged and accepted as a mistake. No harm, no foul. It's like, yeah, I get that. I get that it was acknowledged and accepted as a mistake. We still need to instruct the jury. Just because Brennan said sorry outside the presence of the jury doesn't make it all go away. And I'm not saying we need to disbar Brennan and throw him out of the courtroom. Maybe you guys think so. I'm not saying that at all. I'm just saying exactly what Alessi said. The jury needs to know the truth. That's the point of the instruction. That's the point of the curative instruction, to cure the mistake they made. I hated the way he started this, belittling it and be like, I apologize, so no big deal.
First, by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't.
Come again? Many, many instances of similar type conduct? He's like, we gave him a bunch of options. They wanted the curative instruction. They didn't object to it. There it is. It's like, okay. And then he says many, many instances of similar conduct. Can you point to one by the defense, Mr. Lally, that was similar to this?
The defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel.
Was there a misstatement? There was a misstatement. Was it from the testimony of the witness? Was it a question from counsel? We're not really sure like how this mistake really came out into evidence, and it was a defense witness, so maybe it was their fault. It's like, what? I backed it up so we can listen again. So I don't want you to take my word for it.
Final charge to the jury didn't result in a curative instruction. In many instances, they got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got.
I mean, there was no confusion by the jury. Just ask Lally. He sees there was no confusion, no problem.
Curative instruction at the time, that is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi.
Thank you, Your Honor.
All right.
I mean, was that the worst argument you've ever heard? It was almost like he wasn't there. Many, many instances like this, and they didn't get curative instructions. The defense asked for it. They got it contemporaneously. They should be happy with whatever the judge said. We offered them a stipulation. They rejected it. We don't really know how the misstatement came out. Was it from the witness? Was it from the question? Oh, and by the way, Hank Brennan apologized. So, I mean, that was about as bad as it gets, in my opinion. Can you take us with you on Boston 25 stream? So I will tell you, they said they're going to try to put us on the TV and be on my YouTube stream at the same time. Be kind of crazy. I don't really know. Tech, it's going to make my head spin. We'll see. I think it's a mistake to ask for DUI, lesser included. Won't she almost certainly be convicted of that? Thoughts? Potentially, but I don't know how it is in Massachusetts, but your first time DUI, you're not going to jail. What an unforgiving system. If you don't object right away, too bad. I don't believe Bev considers anything. It is tough. And again, that's the point of a lawyer. There is some grace given in certain circumstances. And again, it's not like they didn't say anything. Before the day ended, they asked for it. She said, no, we'll handle it now. That's why they're handling it now. Do you think it's possible the jurors make a decision tomorrow? Possible. Anything's possible, right? Just ask the engineers. Unlikely, I would say. Love how Hank Brennan is just on his computer during this. Yeah. Peter, don't stop reminding us to like, subscribe, or hit the notification bell. The conversation is so good, I forget to like until you remind us. Thank you for your insight and coverage. I will. It doesn't bother me. I think it's kind of a fun thing about YouTube. I'm in such a serious profession all the time where everybody's so by the book and, old school rules and all stuff. It's like, this is YouTube, man. Hit the like button, right? Who cares? And the people that complain about that, it's like, they're probably not going to be very nice anyways in the comments, right? That's the part that infuriates me. Lally says he rejected the offers. Bev was so rude, the defense wasn't giving him a chance. And at one point she said, never mind, you can just bring the jury in. Exactly. Mary, Peter, you're the reason I haven't quit law yet. I think you quit I think that's what you meant. Hi, Peter, I'm late. Why is Lally speaking on this today and not Brennan? It's not abnormal for different lawyers to handle different parts of the process. Let me make sure we're done with everything we want to listen to here.
Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while. Generally, that will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long.
And they don't have hours of jury instructions, so she's going to be able to get that done.
So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers
They should give them enough time. Thank you, Matthew.
to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, judges, during the last trial,
You just wanted to be 10 minutes instead of 5 minutes, which is fine. Okay, here's what I'm going to do. I'm going to answer some questions, and then I'm going to read that missing witness instruction that was requested. Frustrating the prosecution argument not to fix the curative statement is it's improper to bring it up again this late, yet Bev rushed the defense, didn't say she was supposed to, and then refused to revisit it. Show it. Example 1, Proctor ME photo to discredit the police officer. Sure, I think that's fair, but first off, it did discredit him because he said he went alone and he didn't go alone, but they did a curative instruction where they said exactly who it was. Now, I don't remember if the title Proctor at the ME's office, if that ended up coming in. They said they were going to redact it, but they did multiple things to fix that at the time. But good point. Do jurors get a copy of the rulings for objections at sidebar? No. Especially since a lot of courts allow them to hear the objections in open court? No. Why was Hank hiding behind Lally today? He's hardly allowed Lally to do much but sharpen pencils, paper clips. But today he allowed him to argue all this. Does this seem likely he gave up? No. I don't find it weird at all that Lally did this. Like, not at all. Weak argument equals Lally hates Brennan. When will the lawyers get the final instructions? Whenever the judge sends them. We've gotten them the night before. We've gotten them the morning of. We've gotten them the night before, and they've been wrong. And we had to come in and fix them the morning of. Okay, let me pull up this missing witness instruction here. First, I got to find it. It is page. I don't have the page. All right. Let's just scroll up and find it. Oh, by the way, thank you to Sleuthy Goosey for, it's not letting me share it now. Oh. Still not letting me. I tried to click this one. Play screen. There we go. Is it on now? Okay. All right. Let me see if I can find missing witness instruction here. Credibility, law enforcement. I thought it was early. Introduction, presumption of innocence, proof beyond reasonable doubt, reaching a verdict, role of the jury, evaluating the evidence. Sorry. Thank you to Sleuthy Goosey for sending this to me. She's the one that sent it to me. All right, it's right after the view. How do I keep missing this? Oh, absent witness, because I was looking for missing witness. It's absent witness. Okay. Here we go. This is what was requested to read. They abandoned this. They withdrew it. So we will not be hearing this, but somebody asked for me to read it. In this case, you have heard some reference to a potential witness who did not testify. If the Commonwealth did not call a potential witness to testify and 4 conditions are met, you may infer that the witness's testimony would not have been favorable to the Commonwealth. And I'm thinking maybe strategically, they didn't want to put these categories to make them seem like they had to check all those boxes to confuse the jury and just instead say, Proctor's so bad for them, they were too scared to call him, and still make the argument Still make the argument, but without this convoluted instruction, which I think, okay, I like the idea of the judge reading this to them. I think it would have been great, but I understand their thinking. Here are the 4 conditions. First, the Commonwealth's case against the defendant is sufficiently weak that it would normally be expected to call the witness to testify. I think that box would have been checked. That the absent witness would be expected to offer important testimony that would support the Commonwealth's case. I think they could check that, but I also think, hey, maybe it wouldn't even support their case. Third, that the absent witness is available to testify for the Commonwealth. Easy check box. Fourth, that the witness's absence is not explained by any of the other circumstances in this case. If any of these 4 conditions have not been met, then you may not draw an inference from the witness's absence, and the Commonwealth could have used that. If all 4 conditions have been met, you may infer that the witness's testimony would not be favorable to the Commonwealth if that is a reasonable conclusion in the circumstances of this case. This rule is based on common sense. First, you may not draw such an inference unless the Commonwealth's case is sufficiently weak that it would be expected to bring this absent witness. Okay? Again, maybe those are convoluted and confusing. The defense is like, forget it. Second, you may not draw such an inference unless the absent witness's testimony would be relevant to the defense's guilt or innocence in some significant way. Normally, the Commonwealth would have no reason to bring in a witness who would only testify about a minor detail or who would only repeat what has already been said by other witnesses. Third, you may not draw such an inference unless there is evidence that the Commonwealth was able to bring the absent witness into court. And fourth, you may not draw such an inference if the evidence suggests another reasonable explanation for the witness's absence. Okay? All right. That is the last one I'm going to read. I don't know how to get it back to full. Whatever. It doesn't matter. All right. First trial, Bev told the jury there was a difference between written instructions, Bev verbal instructions. The jury followed verbal, ignore the written. What? I don't know. I don't remember that. Peter, do you think Brennan was writing closing arguments using ChatGPT? I doubt it. But he probably could. There's enough evidence, there's enough information out there on this case that ChatGPT would probably put together an interesting closing argument. Peter, I meant the judge said she saw the shirt and thought the defense knew. Okay. But we saw when she walked out, she can't see it from where she sits. I don't know if she means when she walked out or when he lifted it up. It's a good question. I don't know. Jen, which cross do you think was Hank's worst? I think Dr. Russell by far. She got in the acute grief. He stayed on dog bites for far too long and made it such a huge issue in this case. Instead of minimizing it, he was offensive and she was, you don't want any of that basically on a witness like Dr. Russell. And I actually think my dad would agree. He was shocked at how Dr. Russell went. Okay, I got to run. Love you guys. I'm out of here. Peace out. Hit the like button, subscribe, hit the reminder bell, all those things. We're going to be talking closing arguments tomorrow. Is there an outro? Yes, there is an outro. All right, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time,